please welcome United States Supreme Court Justice Ruth Bader Ginsburg and award-winning author Bryan G. Garner as we conduct an interview by Bill Press.
And Justice, you are the, when you were nominated, the 107th member of the court, only the second woman to serve on the court. If things go the way they may go, that there will be three women on the court for the first time. How important do you think it is that women on the judiciary and the position of women on the court and the issues that come before you?
I think it's important for the president to draw on the strength of all of the people of the United States. That was started by President Jimmy Carter. When he became president, there was only one woman on any federal appellate judge across the country. And he was determined to change the complexion of the U.S. judiciary. He appointed women in numbers. I was a beneficiary of that affirmative action policy. I was appointed to the U.S. Court of Appeals for the District of Columbia Circuit, where Justice Scalia and I were buddies. No president ever went back to the way it was. Now women are about 50% of the law students, so it's natural that they will be more and more represented on the bench.
And one of the women here this evening asked me to ask you a related question, which is that a lot of young women today don't want to be called feminists. They don't like that word, reject the term or the label. Do you consider yourself a feminist? And what is, with as you say, all your accomplishments and the glass ceilings that you shattered along the way, do you consider yourself a feminist, and what does that mean to you?
I surely do, and I think there's a huge misunderstanding. I know some people have called it the F word. But what feminist, male or female, means that you think that your daughter should have the same opportunities in life, that no door should be closed to a person simply because she is female. That's what feminism means, that women should be regarded as people, citizens, equal in stature to men. So yes, I am a feminist.
As am I. So Bryan, I want to ask you a question that the justice might find a little uncomfortable to answer, so I'll ask you. And that is that the chief has said, John Roberts, that judges are like umpires. They don't make the rules, they just apply the rules. Is that what judges really are, in your opinion?
I think it largely is, and that of course judges do gap filling. The legislature passes a statute and tries to typically, in some detail, come up with a legislative framework, but there's no way that a legislature at any level can cover every situation. And so judges have to involve themselves in gap filling. But the question is, how much embellishment can judges do? And there are those who are very restrained at gap filling, and there are those who are less restrained. Today, the Supreme Court handed down a decision in which the court decided on the meaning of prevailing plaintiff. Prevailing plaintiff does not mean prevailing plaintiff's attorney. And it was a case called Astru versus Ratliff. And that was a case in which all 9 justices voted in a way that exhibited self-restraint. I, by the way, worked on the case from the losing side as a pro bono matter. But it was, it's a matter of how adventurous will judges get at embellishing congressional words or whatever the text may be, whether it's a contract or whether it's the Constitution. So
that was the case where the law was clear and certain. But there are many cases, sometimes by carelessness, other times deliberately. An issue may be political hot potato, and Congress really doesn't want to decide it. So it leaves that space. It wants the judges to come to the rescue. So what does a judge do in that situation? Can we say, we want to return this statute to Congress so that they can rewrite it? We have live plaintiffs and defendants before the court, so we have to reach a decision. So gaps can be small, they can be very large, or at the highest level, we're talking about the Constitution. How does one interpret a term like the equal protection of the laws? We all know that came into the Constitution in 1868. It didn't mean, for example, that women were instantly regarded as persons equal in rights. I mean, they didn't get the vote until 1920. But there's no question that today we read the Equal Protection Clause to include women, to include Native Americans, to include people who were once held in human bondage. So I think that the framers of the 14th Amendment, just as the framers of the Bill of Rights, saw those grandly general clauses as having growth potential, as keeping pace with the society as it evolves and changes and matures over time.